Hello, everyone. Welcome to Court with Krissy. Here are 4 short court clips you probably didn't catch, and I'm kicking it off with Judge Norbeck. So if you need a laugh, that's your go-to. And for those that have been worried about Linda, she's still alive. We hope you like it. Court with Krissy and Linda is now in session.
All right,
Yep,
Mr. Coronado, I need you to take yourself off mute so that I'd be able to hear you, and then we will get your case done. Please take yourself off mute.
Okay.
All right, I'm going to read this to you. It says on March 8th of this year on 58th Street in Manlius Township that you had an open container of alcohol in your vehicle. That's the misdemeanor. That is punishable by up to 90 days in jail and/or $300 fines and costs. You also got a civil infraction for refusing the PBT test. That is not punishable by any amount of jail time, but it is punishable by additional fines and costs. Understanding your charges, do you wish to enter a plea of guilty or not guilty on your charges at this time? No, you've muted yourself again, Mr. Coronado. Please take yourself off mute so that I can hear you. Right now, only you can hear me. The little red microphone. All right. Do you wish? No, you muted yourself again. Just tap it one time and then yes. No. Don't tap it twice. Tap it one time. So take yourself off mute. You've unmuted and remuted yourself 2 times now. Mr. Coronado, we only have so much time to sit and wait for you to figure out how to do this. We are done with all the other cases today for 2 o'clock. All right. No, you did it again.
Okay there.
Yes. Do you want to plead guilty or not guilty?
Sir, I have insurance, full coverage insurance in the truck, and I do have the plates, the sticker. I had not gotten
That's
it in the
not
mail.
what you're
I went
charged
to
with.
Elegant.
You're charged
What?
with having open alcohol in your car.
Yes, sir,
and
that I did
refusing to
have.
take your PBT test. Do
Yes,
you wish
sir,
to
that
plead
I did
guilty
too.
or not guilty?
Yes, sir.
Yes, sir. What?
I plead guilty. I did have it
Okay.
open.
Has anybody forced you or threatened you to make you plead guilty?
No, sir.
And are you pleading guilty to this because you believe you did do it?
Yes, sir, I had an open container, and I didn't take the test.
Okay. And that open container was some kind of alcohol, right?
Yes, sir, I had taken a couple of drinks of a Bud Light can.
All right. So I do find that that is a factual basis upon which I can accept your plea, and that your plea is knowing and voluntary. It is just going to be fines and costs. What we mean by that is you have a $70 fine, $100 statutory cost, $50 state cost, and $75 crime victims' rights fee. So the open alcohol costs $295. I'm going to give you 90 days to pay on that. The other one, the ticket, is just $150, but you have 90 days to pay that. If you need more time than 90 days, that's okay, but you have to call the court and ask to get on a payment plan, all right?
Thomas Seeger appearing with on behalf of Mr. Toby.
All right, thank you. And sir, are you Jimmy Leroy Toby?
Yes, sir.
All right, welcome, Mr. Toby. So, Mr. Toby, I know you're lodged in the Antrim County Jail, but despite that, have you been able to generally stay in contact with your attorney regarding these charges here in Kalkaska County?
I talked to him like 3 days ago, I think. 3-4 days ago.
Okay. What can you tell me, Mr. Seeger, then, in between those discussions, obviously not what you discussed, but what the status of this case is, even though your client's in Antrim County right now?
Your Honor, as the court probably recalls, we previously attempted to enter a no contest plea. The court was not in a position to accept it after having reviewed the report. It is my understanding that Mr. Toby intends on entering into a plea to felonious assault with Haida.
And that would be felonious assault count 3?
Yes, Your Honor.
Correct, yeah.
And rather than using the factual basis from a police report, your client would simply admit guilt under a guilty plea then?
Correct, Your Honor.
Is that your understanding, Mr. Ziegler?
It is.
And is it your view, Mr. Ziegler, that HIDA would be a part of the plea in as much as if I decided not to grant it, I would have to allow plea withdrawal?
Yes, Your Honor.
Is that your agreement and understanding as well, Mr. Seeger?
It is, Your Honor.
Mr. Toby, did you hear the terms of the plea agreement?
I told him I just don't remember them.
That's all right. I'll go over them with you. But first and foremost, under the plea agreement, you would be pleading guilty to the offense known as felonious assault. Were you aware of that?
Yeah.
You don't seem very aware of it. You seem to have a large question in your mind. So I want to make sure and go through it step by step, and I want to make sure it's clear to you so that it's also clear on the record. You're charged with several offenses right now: weapons, dangerous weapon, carrying with unlawful intent, conspiracy to commit and carrying a concealed weapon, 2 different counts of assault and battery, and the offense known as felonious assault. The plea agreement is that if you plead guilty to felonious assault, the prosecutor would dismiss all of the other charges. Are you aware of that?
No.
What are you aware of, Mr. Toby?
I don't know. I just don't understand how I can get a felonious assault when I didn't have no weapon in my hand. I didn't use no weapon or anything.
Well, you can, Mr. Toby. So this case is a non-starter once again, and that's fine. Non-starters happen, and when they happen like that, the case can either be resolved by a resolution between the parties and a plea, or we can have a jury determine the issues, and it does not matter to me which. But this case has already taken too much time today, given the lack of preparedness. Mr. Toby, I would never accept a plea from you if you told me you're not guilty. So I'm not going to waste my time going through all of this.
So a felonious, so I did commit a felonious assault.
Well, how did you commit a felonious assault before I even put you under oath, Mr. Toby?
I don't even understand any of this, honestly.
Then you need
I
much
don't
more
understand
time.
I don't understand like how to commit a felonious assault or anything like.
So, Mr. Toby,
I know I did, but I
don't any longer. I muted you on purpose because you have a constitutional right to remain silent and to not have that silence used against you. Your speaking right now out of turn really is not doing you any general benefit, and so I've muted you on purpose. This is not a overly complicated case, but to somebody who hasn't been in the criminal justice system before, which I suspect you haven't, since the offer is for a HIDA sentence, I can understand why the process might be somewhat confusing to you. Good thing for you is you have an attorney that can fully explain all of these things to you if I give him the time to do so. But for him to be able to fully explain it to you, you need to listen. And when you don't understand something, you should seek clarification. When we come back here into court, I won't ever accept a plea from you or any other defendant unless I'm absolutely clear that things are as clear to you as they are to me and as they are to the attorneys. If there's a lack of clarity, I will do what I'm doing today. I will stop proceedings and we will adjourn. Because the only way this court will proceed forward with pleas to felonious matters is if there's clarity. So I'm going to adjourn. I'm going to check in with the attorneys if they think there's anything else I should do today. But generally speaking, I've already made my decision that we're not going to take any further action today because of the lack of clarity. Mr. Seeger, if I provide you more time to talk with Mr. Toby, do you think you'll be able to explain to him the nature of the plea agreement, its benefits, its drawbacks, and so forth?
I can explain the same thing that I previously explained. Yes.
So my understanding is what you're saying is you've gone over those things with him, but you may need to do it again. Is that what you're saying? You've already talked with him about all of those things.
Yes, sure. I can review it with him again.
All right. Well, and that's fine. I understand the circumstance you're in, Mr. Seeger, is it sounds like you've had those discussions, but it's clear to me that Mr. Toby needs to hear them again because he's expressing confusion. Mr. Ziegler, did you have anything else that might benefit the court's analysis?
No, Your Honor.
We will see everyone next month. Mr. Toby, I'll make sure that you're here via Zoom. Can you prepare the writ for Mr. Toby's appearance, Mr. Ziegler?
I can do that, Your Honor.
All right, we will see you next month, Mr. Toby, and hopefully that month of a break and your discussions with your attorney will fully illuminate you so that we have clarity on the record when we return. Thank you.
Are you Jenny Mae Edwards?
Yes, I am.
All right. I have two files here. I have 25A00723OM, the people of Clio City versus Jenny Mae Edwards, and I have 25T01074FY, people of the state of Michigan versus Jenny Mae Edwards. Attorney Zabel.
Yes, Your Honor. Neil Zabel appearing on behalf of Miss Edwards. Your Honor, I had occasion to meet with Miss Edwards, went over her constitutional rights with her. She told me she understood her rights and would waive the reading. Also went over her complaints with her, including the maximum possible penalty on each charge and each complaint. She said she understood the charges and the maximum penalties and would waive the reading of both her rights and the complaints. She's currently not employed, would request a court-appointed attorney.
All right, thank you. Ms. Edwards, Attorney Zabel just stated that he did go over these two files with you, the charges and the maximum possible penalties for the charges in the two files, as well as all of your rights. Do you need me to read any of that to you again?
No, Your Honor.
You know and you understand all of those things?
Yeah.
I'll waive the reading of the charges, the maximum possible penalties for the charges, as well as Ms. Edwards' rights. As both she and her attorney have indicated, she knows and she understands those things, and she does not need me to read them to her again today. We will enter a not guilty plea on her behalf on both files. We will set the felony file for a probable cause conference and a preliminary examination. We will set the misdemeanor file for a pretrial, and we will appoint counsel as requested. Attorney Zabel, what would you like to say in regards to bond?
Yes, Your Honor. Miss Edwards lives at the address listed. She lives there with her mother. She's lived in Genesee County approximately a year. She's 44 years old. She's not on probation or parole. She does have the prior possession of analogs and a couple driving while licensed suspended convictions. I would ask the court to consider a personal recognizance bond.
All right, thank you. She's got quite a few more charges than what she told you about. Multiple controlled substances convictions, identity theft, in addition to what you've stated, Attorney Zabel. So just so you know. Ms. Edwards, clearly you have a substance abuse issue. If I let you out of jail and order you to go to substance abuse treatment and do random screens, are you going to do it?
Yes, ma'am. I start a job on Monday at 10 o'clock also in the morning. So I was just going to mention that also. I would like to keep my job if I could.
Well, here's the thing. If you don't stop doing drugs, you're not going to keep your job anyway. So that doesn't really mean a whole lot to me, right? What means something to me is you not doing drugs. So I'm going to let you out of jail on a personal recognizance bond today. However, if you start testing dirty, if you don't go to your treatment, if you say something like, well, I couldn't go to treatment because I have this new job. No, treatment is your number one priority. Not doing drugs is your number one priority. Staying out of jail is your number one priority. We understand each other?
Yes, ma'am.
All right, on the misdemeanor file, I am going to order a $5,000 personal recognizance bond. Obviously, you're not to use any alcohol, any recreational marijuana, or any illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons or ammunition. And on this file, it will indicate that you are to follow all felony probationary terms. So any violation of your felony, I'm sorry, not probation, I'm sorry, bond. Any violation of your felony bond would be a violation of your misdemeanor bond. On the felony file, I am going to issue a $20,000 personal recognizance bond. Once again, you are not to use any alcohol, any recreational marijuana, any illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons or ammunition. You are to check in with our pretrial services department so they can make sure that you are doing the things I'm telling you need to do. You are to submit to random weekly drug and alcohol screens, and you are to immediately, and by immediately I mean tomorrow, since today is Sunday, you are to go to Flint Odyssey House and you are to do a substance abuse intake and services, and you are to follow all of their recommendations. So if they tell you that you need to go to group meetings 20 times a week, you go 20 times a week. If they tell you you have to go 2 times a week, you go 2 times a week, but you follow whatever recommendations that they give you. Do you understand?
Yes, ma'am.
You're being given a very good opportunity here to show the court that you are able to stay out of trouble. You're able to get off the drugs and get your life in a better position while you're on bond. But if you're not able to do that, then you'll probably just, resolve your case from jail. All right, misdemeanor file will be set for pretrial on, all the other general bond conditions will also be on both of these bond orders, and if you have any questions about that, Ms. Edwards, you can always ask your attorney. Misdemeanor file will be set for pretrial on April 30th, 2025 at 8:30 a.m. and that will be in front of Judge Goggins. And the felony file will have a probable cause conference on April 24th, 2025 at 11 o'clock a.m. Preliminary examination date is set for April 30th, 2025. Those are both in front of Judge Manley. Circuit Court Judge is Judge Norbeck. Anything else, Attorney Zabel?
No, Your Honor, thank you.
All right, thank you. All right, Ms. Edwards, you're all set. Good luck.
Okay, thank you.
Welcome.
Do I just go out then?
Yep, you can go. Bruce Allen Jimerson.
I'm sorry, what did you say your name was?
Teresa Owens.
Teresa. Oh, I do not have you on my list for this morning. Okay, I'm sorry. Okay, so apologies. Did you go by the name Marika Philpott as well?
Only on my bus thing, but not by the name, no.
Okay.
My bus
Is that what was on your driver's license at one point?
no, it's not on my driver's license. No. It been a rape out in Arbor.
I'm sorry, what did you just say?
People been raping women out in Ann Arbor. So a lot of people have to not like hook up and sex, but a lot of women gotta protect themselves.
Miss Owens.
Yes.
Okay.
Just wait 1 second, please.
Yes, please. Okay. So, Attorney Moten.
Yes.
The name that I have on this documentation is Marika Rose Philpott. Is that your understanding?
The jail is saying that this is Marika Philpott. However, when I interviewed her,